Foia, National Security and the D.C. Circuit, a safeguard or a sham. A joint production of the Historical Society of the District of Columbia Circuit, the Litigation Section of the District of Columbia Bar, the Administrative Law and Agency Section of the District of Columbia Bar, and the Federal Judicial Center. With Stuart A. Baker, Assistant Secretary for Policy, U.S. Department of Homeland Security, and former General Counsel of the National Security Agency. Thomas S. Blanton, Director of the National Security Archives, George Washington University. The Honorable Royce C. Lamberth, District Judge, U.S. District Court for the District of Columbia, and James T. O'Reilly, Professor of Law, University of Cincinnati College of Law, and publisher, Foia reporter. And now the program's moderator, the Honorable Patricia M. Wald, former Chief Judge, U.S. Court of Appeals for the District of Columbia Circuit.
Foia, or the Freedom of Information Act, is itself a revolutionary piece of legislation which was signed on the 4th of July by President Johnson and encompassed the unprecedented notion, at least unprecedented to that time, that anybody can obtain information from the government about any subject unless it falls within certain specified exemptions, 9 in the case of Foia. If the government doesn't want to produce within a limited period of time, the requester, after appealing up the line within the agency, can go to court, and the burden is on the government to show why the material is within one of the exceptions. Those exceptions include, besides national security, which is what we'll talk about today, internal practices of the agency, law enforcement investigations, personal privacy, and some others. But the district court is essential in this process, and it is tasked with performing a de novo review of the disputed material and can order its release if the court decides that it doesn't fall within the exemptions. Now, in my day, and I don't know if it's changed, 1 out of every 4 appeals in Foia cases to courts came to this circuit. Now, a word or two about Exemption 1 and its history. Between 1966 and 1974, when it was amended, this Exemption 1 covered all documents, quote, classified for national defense or for foreign policy purposes. That's a big order, a big exemption. In a 1973 case emanating from the D.C. Circuit, the Supreme Court ruled on a request by 26 congresspersons led by Patsy Mink, asking for reports by an internal government committee dealing with the nuclear test at Amchitka Island. The Supreme Court came down very, very heavily on the side of the government. Now, incidentally, for those of you who are real footnote historians, Ramsey Clark argued for the petitioners in that case, and Erwin Griswold and Roger Crampton for the government. Predictably, the Washington Post had already printed a story based upon the leaked reports at the time that the case came up. Now, the district court here in the D.C. Circuit gave the government summary judgment based on a National Security Council affidavit claiming that the documents were indeed classified. But actually, the D.C. Circuit reversed that in part, saying that only the portion of the documents classified, not the whole documents, could be withheld, and only the decisional portions of the documents, not the factual material on which they were based. The Supreme Court majority, per Justice White, seemed horrified by the notion that a federal judge would be authorized to look at the documents, even in camera, and it relied on the legislative history of the then Act to, quote, dispose of any possible argument that Congress intended Foia to subject executive secrecy classifications to judicial review at the insistence of anyone who might want to see them. Now, Justice Douglas, in that case, in dissenting, said the majority had made a shambles of the Act and provided, quote, no means to question an executive decision to stamp a document secret, quote, however cynical, improper, or even corrupt that decision might have been. Justices Brennan and Marshall wrote separately, too, supporting the district court's right to look at the documents to see what had been classified and whether it was legitimate. They said democracy can't function unless people know what their government is up to. So those were more or less the way the issue was joined back in '73, and some say that perhaps it hasn't changed that much since. But that was 1973, and we were still reeling from the revelations of Watergate and an overreaching and secrecy-obsessed executive. So Congress rose to the challenge of Mink. It held hearings which showed, among other things, that the CIA had classified newspaper clippings. The Pentagon paper case was fresh in everyone's mind. So over a very vigorous operation of the Ford opposition of the Ford administration, and indeed a presidential veto, which was overridden by a vote of 380 to 8 in the House and 64 to 17 in the Senate, Congress amended Exemption 1 to limit the government's power to withhold material, specifically to that which was authorized under criteria in an executive order to be kept secret and in fact was properly classified. The court, it said in the amendment, could look at the classified material and determine if it was segregable into what was properly classified and what was not. However, it also said in the conference report that the court was to give, quote, substantial weight to government affidavits concerning the details of classification. Now, Senator Ted Kennedy led the fight for the amendment, and one of our members of the D.C. Bar, Tom Sussman, who was then working for him, did a great deal of work on the amendment. The American Society of Newspaper Editors called the passage of the amendment, quote, a triumph of the press over government stonewalling. Okay, so we're here today to examine how the D.C. Circuit has interpreted the 1974 amendments. And finally, I'm just going to give you just a couple of statistics to put the discussion into perspective. In the intervening years since then, Foia requests have grown exponentially. They have grown indeed 70% since 2000 alone. A recently GAO study showed that while 75% of all Foia requests are granted, that was a surprise to me, in whole or in part, less than 20% that seek information from the intelligence agencies or the Department of State or the Department of Defense are granted. The Department of Defense currently has 18,000 such requests pending. The Department of Homeland Security has over 108,000. The government, incidentally, spends $300 million annually responding to Foia requests, and about 16 million new documents are classified every year. So, the overarching questions for the panel are, I think, how has the D.C. Circuit, both the district and the circuit, managed its stewardship over Exemption 1? Has it drawn the lines between openness and justifiable security well? Is Foia a paper tiger? In fact, is it possible to get anything, ever, on court review that the government doesn't want to give up? Have the courts been too deferential to executive secrecy claims? And indeed, are they really equipped to second-guess the government? What are the biggest impediments to getting information that the government doesn't want to give up? And finally, and I hope we have time for this, we'll ask the panelists notions of what, if any, kind of reforms by the courts, Congress, or even a new administration might be desirable or feasible. So I'm going to begin with you, Professor O'Reilly. You're the repository of all Foia cases. So can you give us a capsulized history of how the D.C. Circuit has performed its duties under the 1974 amendments, whether it's drawn the lines between guarding necessary security and guarding against unnecessary secrecy in the way that Congress intended?
C plus. C plus. It's an honor to be among historians. Though I was trained as a legal historian, the closest I got to the originalists was sitting in class with Nino Scalia teaching at the University of Virginia. I'm not an originalist myself. I'm not even an activist. I ran for the Court of Appeals in Ohio, was crushed by the other side. on the charge that I might turn into an activist judge. So I'm neither an originalist nor an activist, but I want to briefly talk about some of the issues that lead me to give the grade of C+ to this court. Judge Wald has already given you a recap of Exemption 1's history, and I want to underscore that in the 1974 amendments, Congress was very specific about requiring those words, in fact properly classified, in fact properly classified, to be added to the exemption. Now, why does that matter? Because the then obscure Wyoming politician, who was the president's chief of staff, urged President Ford to veto the bill. Dick Cheney got President Ford to veto the bill. The legislation was vetoed, but Congress overrode it overwhelmingly. And I think as an originalist or semi-originalist, we ought to pay attention when Congress stands up to a president and overrides a veto. What's happened in the years since that lead me not to give this circuit an A, as all of us would love to have A's, particularly in these years of great inflation? I believe the D.C. Circuit has had a net negative effect on the 1974 vision of those originalists. They revere the special purpose of freedom of information exposure of what government is doing. They would blame the court for 3 specific failings. First, the federal courts were told by Congress to use de novo review. Those of us who suffered through administrative law know how rare de novo review is since the Overton Park case. De novo review rather than full deference. In the 1974 amendments, judges were empowered to review the actual records in camera, yet they've rarely been willing to do so. And judges were expected to be part of the speedy process of responding to requests, but sloth and inertia among the agencies have been consciously excused by the opinions of the circuit. And so I think it's appropriate to give that grade of C+ and ask the circuit why. I have to predicate by saying I recognize, with all the honor and tradition that's in this court, it's difficult for any scholar to come in and critique. But I don't have a dog in the fight. I don't have any requests pending, and I'm not an advocate for either requesters or the government. I happen to be an elected official in Ohio, but that really doesn't count here. I'm going to begin with de novo review, and to say that de novo review means the judge should not accept the agency's finding without really making an evaluation of what the agency's arguments are and how valid they are. The D.C. Circuit has been outspoken among the 13 circuits in granting deference to the CIA, the NSA, and the FBI. From our view, 700 miles away, it looks like this is the home team playing in its home court. I expect real de novo skepticism from the 1974 amendments being implemented by a court. I think if there were, perhaps there might be some secret torture memos. Perhaps there might be payments to Pakistani military intelligence. Perhaps there might be things that people want to read about that are military or state related, or even less so, but classified. I'm not going to advocate a vicious approach. I'm not going to advocate waterboarding those in the government that are keeping the secret. But I think de novo ought to be honored and not simply ignored. De novo means you're looking at it, as the case in Overton Park says, you're looking at it with a fresh face. Secondly, in-camera review of classified documents by a federal district judge was intended to be a powerful counterweight to the many thousands of agency employees who have the power to classify documents. The sponsors saw the district judge as the umpire, looking at the agency swinging at the number of balls coming toward it with requests, and deciding, as the judge impartially reviewed in camera, what the real status of the classified document would be. But I know my college roommate is a federal district judge. I have a sense of how much burden there is of these cases. It takes inconvenience. It takes time to actually read the documents and evaluate their contents against the norms in Exemption 1, and particularly in those executive orders that have changed from administration to administration. This circuit seems to tolerate rejections or the omission of in-camera review more than the Ninth Circuit. I encourage you to read the Ninth Circuit's case called Lion Raisins, as an example of the court saying you should be doing in-camera review at the district court level because agency affidavits are a poor substitute. It was the core element of the veto in 1974 when Cheney and Ford objected to what in-camera review could do. They were overridden. I think today Cheney and Ford could have just sat silent, because if they'd foreseen that so few in-camera reviews would be done, they wouldn't have had to bother with the veto. We can all admit the trial judge has a difficult caseload, very difficult caseload with criminal cases, Speedy Trial Act, and the like. Reading State Department cables for hours and hours behind locked doors with a guard outside is not what the district judge wants to do. But ultimately, we're reducing the rights of the requester to have greater free access, greater free balancing. And we recognize from that veto and its override that Congress wanted in-camera review for a reason, but the authority to do so seems to be honored in the breach. Third, a reasonable speed of agency response was expected by the sponsors of the Freedom of Information Act. They were not bureaucrats. They were the California, Texas, and Illinois newspaper editors who headed the respective committees of the American Society of Newspaper Editors. They're journalists. They knew that stories get cold if you were stonewalled by the person that holds the documents. But the decision of the D.C. Circuit in the Open America case allows an agency to excuse the delay of response by virtue of its backlog of requests. And that, indeed, chills requesters, so that out there in the hinterlands where requesters are sending in their requests, they feel that Open America has backlogged indeed because the D.C. Circuit has permitted agencies to respond, we don't have to honor the 20 days because we have a backlog of cases. And if you do that, that is indeed a perverse incentive for agencies simply to say, well, we've got a backlog. We're not going to spend any more of our appropriations on the Freedom of Information function. We've got a backlog, and because we've got a backlog, Open America allows us to delay. Congress faced that in 1996, and they put in a new test called unusual circumstances. Again, agencies grabbed the opportunity. They cited their backlog as being unusual circumstances. Virtually none of the agencies between 1996 and 2000 devoted the number of personnel or the number of resources needed to meet the volume of requests. So if there is an abuse, the abuse is one involving the requests not being met because of the use of the backlog excuse under Open America. So what would the originalists look for? As briefly conclude, the originalists, the American Society of Newspaper Editors, thought that requests would go directly from the agency back to the requester with the answer. How foolish. What actually occurred is agencies didn't give either the documents or the prompt response. Requests that were denied would go up to the district court. The originalists thought the district court would read the documents and determine what is or is not exempt. The trial judge does not accept the agency's claims in a de novo circumstance. There's a full presentation of both sides. The district judge is going to look at the actual documents and make the choice. This is not the world of today. The pragmatic view, perhaps, the approach taken by the D.C. Circuit, cut the agencies more slack than those originalists in 1967 and 1974 would have allowed. Whether the agency needs further attention from the appeals court is for the appeals court to decide. But it has been business as usual inside agencies for too long relative to what was expected by the American Society of Newspaper Editors. Finally, who wins if the jurisprudence were to shift back toward the original view? The press wins, the public interest group wins, the non-government organizations, the state and local officials will fight with the bureaucracy here in Washington, and of course, those ubiquitous federal convicts who are using the Freedom of Information Act virtually every day. Who would lose? Well, the original targets were the Pentagon, the Justice Department, the administrative agencies that are struggling to change direction with edicts from above, not accompanied by appropriations to meet those edicts. I'll say for the record that because I don't have a particular case or even a request pending, it's easy for me to say it's difficult for you, particularly in the administrative agency people that I've met today, it's difficult for you to deal with the circumstance that Congress has not fully funded and not fully equipped. So, as we look at the history of the Freedom of Information Act and of this circuit, and we think of how our advocates had fought to override that 1974 veto by President Ford and Chief of Staff Cheney, we should look again at those now overlooked rights, re-examine de novo, re-examine in camera, and re-examine the prompt response in light of that history.
Thank you. I think we'll get a view from what I'll call the loyal opposition, now from Stuart Baker, who's representing the government, the Department of Homeland Security. The overall question would, of course, be the same one that I put to Professor O'Reilly. How do you appraise the court's interpretation of Exemption 1 in a general way? But I think even more critically, as a government policymaker, and you've seen it both in the National Security Administration and in your current job in Homeland Security, I'd like to know a little bit about what happens inside some of these security agencies, such as the two you've worked on, when you get a request. How far up the line does it go as far as the decision to refuse or to grant? Is there ever any attempt to balance a public interest with a degree of risk? And maybe you could give us a few examples of what has been given out and what has been refused. And finally, you and I, in prior incarnations, have, I think, agreed that sometimes, or actually quite often, the government overclassifies. And I'm wondering if in your current position you still feel the same. In that line, I'm just going to quote you one line from Erwin Griswold after the Pentagon Papers, who said, "It quickly becomes apparent to any person who has considerable experience with classified material that there is massive overclassification and that the principal concern of the classifiers is not with national security, but with governmental embarrassment of one sort or another. There may be some basis for short-term classification while plans are being made or negotiations, but apart from details of weapon systems, there is very rarely any real risk to current national security from the publication of facts relating to transactions in the past, even the fairly recent past." Now that was in the 1970s, and this is the 2000s, so go ahead. Answer in 30 seconds or less.
Okay, no, I'm glad to do that. I want to stress, however, that I have the freedom of being a recovering lawyer in my current position. I am a policymaker and not a general counsel, as my general counsel often reminds me. So I thought I'd start, rather than talking about the legal issues, with just how the FOIA cases look to those of us who are making policy. And I have had some experience with FOIA personally, and particularly in my last job, and in some respects, FOIA cases are among the most personal of lawsuits or demands that people can make on high government officials, because at bottom, when I get a FOIA request for stuff that includes files that I have to go back and spend Saturday going through my files to see what's responsive to those requests. Even if we're going to deny it, it's Tom Blanton's name that I have on my lips when I tell my kids that I'm not going to go to the soccer game. So it is a very direct and personal intrusion into the lives of officials when they get a responsive request for their documents. Never more personal when I was at NSA, an agency which is famously forbidden from assembling dossiers on Americans. They have to focus their intelligence outside the United States, so their intelligence gathering. We received a FOIA request for every document Stuart Baker had ever read or written. And so the only dossier on an American, as far as I know, that NSA has ever assembled was as a result of a FOIA request filed by somebody at an NGO who really didn't like me. I do think that I actually also filed a FOIA request once to collect the various documents that had been assembled in the first background investigation that was done on me, because I wanted to have all those documents if I ever needed to file to get another background investigation. And I even have my favorite weird classification decision because they had carefully, they had all the interviews that they had conducted of everybody who'd ever touched my life that the FBI had encountered. And they carefully blacked out the names of the agents conducting the investigation who I would not have known from Adam, and left in the names of all my friends and everything they said about me in this candid moment. So I think that there's no doubt there are errors in FOIA classification and declassification that we've all experienced. Coming back to the question of, you know, how's the court doing and what does this look like from the inside, I think the thing that we might forget, but which is obvious or unstated, is all of these decisions are made by government employees. And of course you might say, well, duh. But that actually makes a big difference in every respect and every aspect that we've talked about already today. First, on the question, do we balance risk and the public interest? Let's remember, these are decisions made by government employees, and they are employees who look at FOIA requests. The first cut is done by people who do nothing but respond to FOIA requests. And nobody likes to think that their job is unmitigated evil, that they are serving the devil when they carry out their job. So not surprisingly, the people who review documents in response to FOIA requests believe in FOIA, and they think that they should be producing documents. And so I can't tell you how many documents have come to me in which somebody said, well, we just thought it would be a good idea to hand it over, notwithstanding that it seems to raise sensitive diplomatic issues. So my sense is that at the working level, on a day-to-day basis, our FOIA reviewers give the nod to disclosure rather than withholding of the document. That may be unique to us, but I suspect that that's pretty common.
I can interrupt
Yep.
just 1 second because I think it would help us all. Can you remember any specific example? I don't care whether it came out of your NSA experience or your DHS experience, of something they have actually said, yeah, you can have it.
Oh yeah, no, it was quite common to get stuff. Now it's still all in process, but I would say there were a number of documents where the FOIA staff said, we think we ought to release this, and in some of those cases, when it was reviewed more closely, people said, no, actually, they've underclassified the material. I think the fact that it's government employees also shows up in a second way. Both the classification is performed by people who are rushing to get their job done and doing as good a job as government employees can be expected to do when processing large amounts of material. And then when they are trying to decide what should be declassified or what can be disclosed, there are lots of errors made both in disclosing too much and in withholding too much, blacking out too much. I think the problem there is that at every turn we're trying to process massive amounts of information, and people are not doing, a perfect job. So that when the courts review the decision to disclose, when you have two sets of lawyers plus a judge examining the material, you're bound to find that there were errors made in all directions. And I'm confident that that is going to continue to happen. Which brings us, I think, to the last question, which is how come it's taking so long to produce this stuff? I'll set aside the question whether we should adopt the rule of statutory interpretation that we should choose the interpretation that will most annoy Dick Cheney. Notwithstanding that would be an entertaining statutory construction rule. I do think that as a policymaker, I live with laws, hundreds of laws that we deal with every day, which command us to do things that we can't do. We don't have the money to do. We don't have the people to do. And pretty quickly you get used to the idea that notwithstanding what the statutory mandate is, Congress determines what it is that you really must do and can do every year with its appropriations. And what I think we've seen in the Foia area is that the appropriations have been insufficient to keep people current and careful in everything that they disclose through Foia and that they withhold under Foia. My prediction is that that's not going to change. Congress is pretty comfortable with the level of staffing for Foia disclosures at this point. And what the court's decisions in Open America and with respect to in-camera review really reflect, I think, is a decision that the court can't ride against the tide of appropriations, the massive tide of material that has to be disclosed, that's going to be fought over. We're simply not going to get an ability to deal with that on a retail basis. It's going to be dealt with wholesale, and it's going to be dealt with on the basis of, appropriations committee decisions about how many Foia people, how many Foia staff they really want to have. To have judicial review cure that would be bailing the ocean with a thimble. Right?
I'll give you a B+ on that. I'm now going to turn to Tom Blanton, who is a steady customer of Foia, to get his appraisal, basically, of how Exemption 1 is working, especially in this circuit. But I guess my basic question to you is, because I think I can predict that you're not going to be thrilled with the way it's working, that where you think the problem lies. Stuart has alluded to one possibility, Jim has alluded to another. Do you think it's overclassification by the government? Do you think it's the fact that Exemption 1 is structurally dependent upon a classification? I mean, you can only get it if it wasn't properly classified. Do you think that the courts really are equipped to second-guess the government on when classification is proper or not? Is it the fact that we have these interminable delays because of overwork? And I hope you're going to share with us briefly some of your exotic experiences with Foia. But the basic question is, do you think you can really get anything out of Exemption 1 anymore? And what can the courts do better than they're doing right now? Okay.
Yes. And the simple answer to the question, I think, safeguard or sham, and there's a very simple answer, which is it's a safeguard, I would say, when courts actually review. You can get something out of court review if courts actually review. It's a sham. Yes, it does happen often, and including in this circuit a few bright lights, and I'll share a couple. But it is a sham when courts take the D.C. Circuit's standard of utmost deference to government affidavits. Because we have this extraordinary, it's almost like a DNA database they're using for the Innocence Project. Because of the Freedom of Information Act, because of the secrecy reforms in the 1990s, there are literally more than 1 billion pages of secrets that the government once kept that are now out there in public. It's a database. You can then go back, look at those court decisions, those arguments, those historic cases, the state secrets cases like Reynolds or the Pentagon Papers case. We now have the secret briefs in the Pentagon Papers case. We now have the document that was at issue in Reynolds that set up the state secrets privilege. Guess what? The government affidavits misled the court. Now, was it out of deliberate wanting to lie? Well, yes. In the Korematsu case, we now have the documents that show the Justice Department lawyers knew there was no security risk from the Japanese Americans, and yet, all the way to the Supreme Court, they upheld the internment because they didn't question. And that's, I think, the core of it. When the courts question, you get real access. And I'll give you a great example, D.C. Circuit example, that Judge Wald actually was part of, so she'll have to recuse herself from this discussion. But the United States launched a hostage rescue mission for our hostages in the embassy in Tehran in 1978. It failed out in the desert miserably. Americans died. The Carter administration arguably lost the election in 1980 because of this failure. The Department of Defense conducted all kinds of after-action investigations to say, what went wrong and why don't we have this capacity? How come the Marines and the Army and the Air Force couldn't work together? And they amassed file cabinet drawers, 12,000 pages of the after-action investigation. So An enterprising Washington Post reporter named Scott Armstrong, one of the founders of the National Security Archive and its first director, filed a Freedom of Information request, said, we want those documents. But the Defense Department's objection, wait a second, this is top secret code word, all 12,000 pages. Now, lucky for us, we got Judge Oberdorfer, who had seen enough government secrets over the years. He was a little bit skeptical, and he took our suggestion to appoint a special master, Ken Bass, who had also seen his share of secrets over the years as the government's chief lawyer for the FISA court. Well, can I just say that after 2.5 years in the special master process, and the government fought it all the way and took it to the D.C. Circuit, tried to mandamus Judge Oberdorfer and prevent him from appointing a special master to look through these documents, because no way was Judge Oberdorfer going to go through 12,000 pages in file cabinet. Judge Wald wrote a nice decision, got Ken Starr on board as well, that said, this is a reasonable way to deal with this kind of problem, a special master. Now, have we ever had another special master in a classified information case in the D.C. Circuit? No. Just a pure lack of imagination, I would argue, by a number of judges. Although I like Judge Lambert's idea of sampling, because on sampling you get some interesting ideas. And let me tell you the last document we got loose from the review by the special master. The last time, we got 8,000 of those 12,000 pages were ultimately released in over 2.5 years. And the last document in the last conference, sitting at the conference table as we agreed to settle the case because they could tell us in good faith at that point that everything else was about our government's capacity to rescue me if I get, hoisted by the dictator of Uzbekistan. Well, I'd like our country to have that capacity. I have some interest in that. The last document was an after-action report from the helicopter pilots from Desert One, recommending to the department that they no longer include milk in the box lunches because it spoils in the desert heat and makes the cockpits uninhabitable. Top secret code word. Second great example of the D.C. Circuit, not a B1 case per se, but the White House email lawsuit that came up to the circuit several different times, forced one of Judge Lambert's favorites, a sampling of the White House email tapes. And I have a fun handout. It's a party favor. Everybody gets a copy. I've got a little stack as you walk out the door. This is, if you can see, it's one piece of White House email to a fellow named Colin Powell, who missed a meeting in January 1987, so they took notes from the meeting and sent it to him and said, here's what happened at the meeting. The meeting was about how to put together a support package for a guy named Saddam Hussein, who was then fighting against a country named Iran. But we were on Saddam's side, and so they were talking about sending carrier battle groups and how we're going to move arms through the Egyptians. And this copy of that email was reviewed on and released on June 6th, 1994, and this was released on June 15th, so 9 days later. And if you can see, just visually, if you slid the two copies together, you'd have all but one line. All but one line. And this is classified at the level of secret, which is real damage to American national security. Well, the punchline of the story is that the review, usually we see these things because the State Department will review a document one way and maybe the CIA will review it another way, and different agencies don't know what the left hand, right hand is doing. In this case, it was the same reviewer. Looked at it 9 days apart. Senior reviewer, years, decades of experience in national security classification, just got this copy from one user area, that copy from another user area. I called him up. I've known him for a long time, respect him a great deal. I agree with Stuart Baker. Most reviewers and most processors and most government employees look at the Freedom of Information Act as the law, and they salute. And they try to carry it out to the best of their ability. There are outliers. Judge Lambert usually gets them in his court and slaps contempt fines on them, but that's a whole other story. But in this case, I called him up and said, what's up with this? There's only one line that's black in both versions. And he said, okay, I'll give you that. I said, but what were you thinking? He said, well, there must have been something in the Washington Post this week that was about, Iran and Iran arms, and so that sounded really sensitive when I saw it, so I blacked it out. But, 9 days later, nothing about Iran, but a big thing about Egypt and Libya, so had to black that out. Sorry about that. Here, take the document. This is how secrecy actually works. Secretary of Defense Don Rumsfeld's department had sworn testimony to Congress that only 50% of what's classified is overclassified. When Jim gives a grade of a C+ to the D.C. Circuit, I would say no. Actually, the D.C. Circuit has flunked because the D.C. Circuit has adopted a pretty much utmost deference test to these affidavits when the actual evidence shows 50 or 60% is as good as the government agencies usually give it.
Other circuits do better?
True confessions, Judge Wald. We forum shop. We brought a case against the CIA for the President's Daily Briefs, and we didn't bring it here in the D.C. Circuit. We went to the Ninth Circuit. Jim O'Reilly's right. They look a little closer at the document. They actually said, wait a second, President's Daily Briefs, 40 years old? You can probably release those. Of course, the two that we put at issue in the case, where we had the PDBs from the day before and the day after, that we've had them for years, the court refused to look at themselves. So even the Ninth Circuit, not the best. Yes, other courts do better, but when the review happens, you really do get results. I put the grade down in the 50, 60% in my daughter's school. That's a flunking grade. That's about an F. When the National Archives just did an extraordinary audit of how the reclassification of released information happened and how agencies went through and took stuff out of the public shelves and stuffed it back in the vault. And they did an audit of those decisions, and they found that only around 60, 65% of those decisions were defensible under the standards. So you're saying that on 25 and 30-year-old documents, they only get it right 65% of the time? That's an F. And yet those are the affidavits that get accepted by the courts under the D.C. Circuit standard, and they tell us to go away. But we won't.
Finally, we come to Judge Lambert. Some might say, if you're a Bible reader, it's like the wedding in Cana, the best wine is saved till the last, but at least most of the questions certainly will be saved to the last. And obviously the judge is a pivotal figure in the Foia Exemption 1 equation, and it's the center of the enduring debate. If we went back to the quotes I gave you from White and Douglas way back in '73, and in later Supreme Court cases, it's always a debate between whether or not the federal judge is equipped to and should be allowed to, in effect, or under what circumstances, second guess the executive agency. So basically the questions I'd love to hear the answers from Judge Lambert are how he approaches a Foia Exemption 1 appeal. The statute, of course, does say de novo review, but also the statute also says that there is an exemption for something that has been classified under criteria in an executive order and properly classified. How does a judge go about deciding whether or not a classification has been proper? Professor O'Reilly says in his treatise that after reading all these cases, every single one under Exemption 1, most of them fall by the wayside at the affidavit stage. They never even get to discovery or to in-camera review or to deposition. So what are your criteria for when you would actually look at some of these documents themselves? I think and finally, the last thing I'll just mention is, what do you do with the so-called mosaic theory? The mosaic theory, which I think most people in Foia are very familiar with, is the notion that the Supreme Court and our own circuit has endorsed in several opinions, saying, well, you know, even an innocuous little bit of information like you talked about, Tom, you know, our enemies there can put that together in the jigsaw puzzle and the mosaic with a lot of other innocuous pieces of information, and suddenly they'll see something which really does pose a security risk. And how does the requester ever be able to circumvent the mosaic theory? It's all yours.
First, the mosaic theory is very well settled in the D.C. Circuit. I agree with it myself, and I think it makes sense that we have to pay attention to that, and the D.C. Circuit does. I think I approach a case from the standpoint, it would be troubling to me to think that a court could or should substitute its own judgment about what's properly classified in the interest of our country's national security for that of experts in intelligence gathering in the intelligence field. But the general notion that we should give deference to the intelligence agencies and to the executive, to me, makes perfect sense, but deference is not blind deference. And I guess that's where I would differ from some judges and lean more to what both Tom Blanton and Professor O'Reilly are saying, that a judge's role is not to be a patsy for the government. And
those of you in this room who know me obviously know that's not a role that I would ever be comfortable playing. A judge can probe, even in a B1 case where we're talking about national security matters. A judge can, and I think should, get into the nitty-gritty, examine the claims, and carefully review the wording of the affidavits and see if they really do fit the current administration's executive orders. Part of the problem with this is each administration, of course, changes the executive order, changes the criteria for classification. The current one we're working from is one President Bush did in 2002, repealing the one that President Clinton had done in 1995. And so we're always going to have changes with each administration with new wording and new ways of interpreting what is properly classified. But the judge's role is to go start with that executive order, which sets up the criteria, compare it to the affidavit, and see if it makes sense on its face. I think that judges all do recognize that the Freedom of Information Act is one of the most important tools that our citizens have to hold the government accountable for what it either does or doesn't do. And it's the judiciary's role to ensure that the statute is working properly and that the executive is carrying out its duties under the statute properly. And I think that most judges, and certainly I recognize that it's a fact of human nature that we all either cover up or hide our mistakes if we can. So that obviously there's a natural tendency to not want to produce materials that would be embarrassing or otherwise reveal information that's not helpful to the current administration or the current government view. And I think judges have to recognize that that's part of what we're looking for when we're looking at what's going on in the case and what's really happening in the case. Judges are the outside force that can ensure that there really is a valid base for withholding a document. I'm going to read the briefs in the case. I'm going to read the Vaughn Index. I'm going to read the affidavits before I rule. And if I don't really understand it, I'm going to get the documents in camera, and I will do it. For some reason, by luck of the draw, I've had an uncanny number of cases with 1 million documents. I'm not going to read 1 million. I don't know about 12,000, but I know I'm not going to read 1 million. So I have developed the idea that you got to get the parties in at the outset in these 1 million document cases, and you got to talk about sampling, and you got to talk about how you can pick a reasonable sample out of those documents and work from the sample. And then once you have the sample explained fully and documented, and you read what they've suggested as a justification, rule on the sample, and then let that ruling apply to all of the documents that have the same category. And I have found that that works extremely well in these large document cases with the sampling technique. You can't do the sampling technique unless you really beat up on the parties to get them to agree on how to do the sampling, because otherwise it'll never work. But the plaintiffs have an incentive too, because they know I'm not going to read 1 million documents, so they know they have an incentive to try to work out a way that all the three of us can work together to get to some reasonable way to approach the big document cases. All the cases aren't big document cases, and certainly in the smaller cases where I'm not satisfied that I really understand what they're saying in the affidavit, I'll ask for the documents in camera, albeit the government doesn't like it when I do that. And I will say I just had one where it depended on, if I read the affidavit a certain way, it made perfect sense and I could rule for the government. But I wasn't really sure that's what it meant. I could have gone through a lot of procedures. I just found it simpler. Get the documents, see if that's what it really means. I got the documents. I was right in what the government was trying to say. They just hadn't said it very well. In my opinion, I laid out what the government actually was doing, so the plaintiff wasn't disadvantaged by my in-camera review. But I think judges are somewhat sensitive to in-camera review in the sense that we're doing it secretly without the plaintiff really knowing the basis for everything. And so judges are reluctant to do in-camera review because we feel like if you can decide it on the open record, it's a more fair procedure. We're used to an adversary procedure. We're used to not doing things in camera. And I think part of the reluctance of in-camera is it's the adversarial system doesn't promote in-camera review. It doesn't encourage us to do in-camera review. This is one of the few areas where I think a lot of more in-camera review might make sense, but judges are reluctant. because it does somewhat defeat the adversary system if you do in-camera review. I don't agree with the criticism of Open America. I think Open America can be made to work. I think a district judge has so much discretion under Open America that I can force the agency to do it by whatever deadline I want to set. I had one of these not too long ago where the plaintiff really wanted the documents before the last election, and I thought they really had a justification for trying to get the documents before the last election. But there were a lot of documents, so it would mean other requesters, if I set a deadline, other requesters are not going to get their documents because the agency is still going to have a finite number of people that they can work on these cases. And I think I had the flexibility to set a deadline. The government moaned and groaned, but they lived with it. They didn't mandamus me. They didn't try to appeal it, and they produced them by that deadline. And it was in 30 days before the last election, and it worked out in a way that I thought made perfect sense and was justifiable. And I thought Open America gave me the full authority to do what really needed to be done there. So I'm not as opposed to the idea that Open America can work. I think it does give a district court discretion. Now, one judge said to me today at lunch, well, Open America only applies it to the FBI. That was the only agency in the case. Of course, that was in jest, and all judges know Open America really does apply across the board. But Open America is frustrating to every judge and frustrating to every requester. But part of the problem is Congress is just, when you say the figure, Congress is appropriating $300 million just for Freedom of Information Act. Now, it's hard to say that Congress is going to give more for Freedom of Information Act cases. They're not. There are other reforms we could think of, like cutting out some of this prisoner nonsense that might speed up the requests from newspapers and other people that would have more public interest. There are lots of things that could happen to reform the area, but I don't think that speeding up the process by any other kind of absolute deadlines or anything is ever going to work. So that's my spiel.
Let me just ask you one question. Have you, in 1974, when they did this amendment, they thought they had done a great thing when they said, aha, after the Mint case, we're going to add now that the judge can decide whether something has been properly classified. Is that realistic at all? Have you run into any cases or many cases where a judge can go behind the classification?
I have never done it in my first 20 years as a judge. I'm not saying I will never do it, but I think what would be most troubling to me is if I was unable to find out the information that the intelligence professionals in the agency were supporting this withholding, and they're explaining to me what the real basis was. If I thought it was really political decisions being made at the higher levels of the agency that weren't supported by the intelligence professionals, it would give me a lot more pause about what the agency was doing. And in every case I've had, I've been able to, either because I then want to question the affiant or in some other way figure out that this is really supported by the intelligence professionals who should know what they're doing, who do understand the mosaic theory, who should be able to explain to me why this sentence or this paragraph really would hurt us if it was released. And if I'm doing a sampling, I can do that sentence by sentence or paragraph by paragraph. If I'm doing a million documents, obviously I can't. But when I'm doing a sampling, I can get the analyst there to explain it to me in a way that I can understand. And I've always had the ability to get that out. If the agency couldn't satisfy me, I've never had an agency yet that didn't go ahead and declassify and release the document without my having to make the decision that I would do it myself. Because they knew how foolish they looked when they were trying to explain it.
What do you do when the so-called Glomar defense comes up? The Glomar defense is something named after a case here in the circuit where the government says we can't confirm or deny the existence of the documents that that have been requested. And what happens then?
It's the most difficult problem because the plaintiff really can't know anything. Yeah. You've got to really do everything in camera when that's the defense. And there's really, the adversary system is really out the window at that point. I think because judges recognize that it is a really awesome responsibility that we're not even letting the plaintiff participate in the process, that we know we've got to move very carefully and really look carefully at the evidence in that kind of a case.
Likely to go look at it in camera.
I would be.
Yeah. There's been a lot of ideas, a lot of comments, a lot of evaluations put out on the table. So I'm going to begin with you, Tom, and let the panelists pick the ones that they want to take a minute or two to address. Tom.
Just on the Glomar case in this circuit, again, we now have many of the documents that actually were at issue in that case. And guess what? The government could have confirmed or denied, because what was actually being covered up, the CIA built a ship with the help of Howard Hughes, the billionaire, to send a claw down to pick up a sunken Soviet submarine on the bottom of the Pacific Ocean and bring it up, because they wanted to retrieve the missiles, the codes, the command books, and this highly top secret, would have been very offensive to the Soviets, very diplomatically sensitive, and the like. So it turns out the United States Navy had told them they were stupid to try, that they ought to send down a submersible. The Navy had had a lot of experience getting things off the bottom of the ocean. They should send down a submersible to pick up that stuff. It wasn't going to work to put a claw down and build up. But in their arrogance, which goes hand in hand with the cover of secrecy and the absolute protection of sources and methods and deference to intelligence professionals and their judgments, the CIA went ahead and built this thing, scooped up the submarine, started hauling it up out of the Pacific Ocean, and lo and behold, the currents broke it in half, and this time when the sub hit the ground, hit the bottom of the ocean, it exploded into bunches of little bits. And guess how much evidence we ultimately were able to give up? Not a lot. A few remains of Soviet sailors that we handed back to the USSR. Lesson: behind almost every government secrecy claim, there's some room for release of information. And every time the courts actually tell the government, review this again, do a Vaughn index, get somebody in here who knows what they're talking about, the plaintiffs get more documents. We may lose the case ultimately. There's going to be a ruling against us down the road that says there's something here that's still a secret, damaging national security, we're not going to let you have it. But if you have any kind of serious review, and there's all kinds of ways for judges to do that, with special masters, with Classified Information Procedures Act kind of summaries, with in-camera review, with all that kind of pressure, you can create a far more adversarial process, and it's up to the judge. And one of the past masters is right here.
Okay. Stuart, I'm sure there are some things that have been said that you'd like to have a right of reply to, so go ahead.
I think that probably the thing that's troubling about the approach to Open America is that essentially it sounds like the tactic is to try to get the judge mad at the government so he's willing to disadvantage all of the other people in the queue. The fact is there is a queue, and somebody who is able to hire lawyers and think tactically is trying to get an advantage on everybody else who's in the queue who may not have hired a lawyer and is just playing by the rules of the statute. And I think it's very easy to forget that when you get in the heat of the individual case that you have in front of you, which is adversarial and where the government undoubtedly will be disclosed to have not done everything perfectly. But it's worth remembering this is more in the nature of an action in which the government is saying, well, we have these resources. We think it's fair to handle the requests as they come in, and the judge is really being asked by another party to take a different view of that.
I think Tom's agency did some sort of survey that I read about in the paper. Some of the requests have been there for 10 and 15 years, and you have 108,000 requests. I mean, what's the solution there?
Well, we do have 108,000 requests, and almost all, probably 80–90% of them are individuals who've asked for individual files that are relevant to their individual immigration status, which doesn't have a lot of sex appeal, but is really important to those folks. They're all immigrants who need their records. And we only have so many people who are able to respond to that. We ask for money, and either OMB or Congress decides that that's not the most important thing to do with our funds. So we're stuck with insufficient resources, the question is who gets served with those resources. It's not an easy decision, but it's also not one that's well suited to an adversary proceeding by one of the parties saying, "It's me, I'm the one." So on the Glomar case, I'm willing to bet that you can always find something that you can characterize as a scandal or that is a scandal in a government program. That's certainly my experience. But the fact is, what Glomar I think stands for is the fact that we were trying or had tried was part of the secret, and so to acknowledge that we have 30,000 documents on an operation that we were trying to pretend we'd never done for good national security reasons, as well as possibly bad, the very release of the Vaughn Index releases the secret. And so I don't think you can dismiss it by saying, yes, but we found something that is arguably a scandal that was being covered up by the classification of those documents.
There's a piece of legislation that's pending. Nothing will happen to it in this session. It kind of follows the same line, only more so, of the things you appear to say probably won't work. It has more time restrictions, as I understand it. It has an ombudsman, has a tracking system on it. Do you have any thoughts on that?
Yeah, I do think because this is at bottom resources, all you're doing is allowing the people who have the best lawyers or the best access to lawyers to jump the queue when you set up those sorts of rules and then let people enforce them by going to court.
Jim, do you have some thoughts about anything?
I was the chair of the ABA section of administrative law when we worked on our ombuds project, and we convened a meeting in London, had many of the European ombuds, and they said this is a great example of a function on which the ombuds can have a real beneficial effect, that the public sense that the agency is open or transparent or willing to respond is enhanced by having an ombuds role. I think the Connecticut example, what Bob Freeman's done in Albany, New York, and state government, what the Virginia Committee's done, those are examples of the states as laboratories of democracy, showing us that ombuds functions can work.
Does the ombudsman have any substantive authority, or does he just kind of make sure things don't get stymied at a certain level in the agency?
That's a delicate question. It's going to depend with each of the states. I was a consultant to the Trudeau government when Access to the Information Act was adopted by the Canadian Parliament. They gave teeth to their ombuds. Virginia doesn't have it. Connecticut has somewhat of teeth, and New York more of it. But it's going to vary with the legislative compromise. The points I'm going to take back to my students are, there is indeed a natural tendency to conceal our errors. It's basically human. And it's beneficial to have an outside force to assure the validity of the position being taken. But an agency that cannot explain why it's keeping a secret cannot ultimately defend the secret. Those are very interesting and very worthwhile comments. An agency that cannot do a good job in its Vaughn Index and articulate to the judge, either in the public Vaughn Index or the secret Vaughn Index, if there has to be one. If the agency can't articulate why it's keeping it secret, they can't defend it. There are myriad examples of those, and I'll skip over many of them, just to say an agency that cannot explain why the record should be properly classified under the executive order probably shouldn't be classifying it at all. The natural tendency, which he stated, which I completely agree with, agency people want to do the right thing, but they want to do the right thing within their sphere, and their sphere doesn't involve exposing what they're doing to a wide variety of other people. That's what the outside arbiter, that's what the judge is to do, and I believe it's important for the judge to be a full and fair umpire of the balls and strikes of the requests and the agency's responses.
To what Stuart was saying, that it all comes down to resources. I would say it doesn't all come down to it. Resources are a huge issue, no question about it, throughout the government. But we've done now, our brilliant General Counsel, Meredith Fuchs, has supervised 7 government-wide audits of how agencies actually perform, where you file Freedom of Information requests on the same day with 90 agencies, and say who gets back to you first, and how long it takes, and how much they give you, and how much trouble it is to get them to fess up. And what we found was in agencies like the Air Force, people would come in on a 3-year tour, and the person leading the FOIA shop with sort of the unfilled FOIA request just kind of got slid off the desk into the trash bin on their way out the door. Well, not going to leave anything for my successor. That's where some of the reforms, like in the Cornyn-Leahy bill, to just make them track them. I mean, if you can log on the web and find out exactly where in outer space your FedEx package is at this exact moment, we ought to be able to know where your FOIA request is in the agency. But if you called the Department of Labor, they couldn't tell you. They send them out to all their decentralized components. They can't tell you even where it is. I mean, we've gotten sequences of letters from some of our FOIA requests where it creates this endless daisy chain that reminds me of that old Boston Charlie song, you know, will he ever return? No, he never returned, and his fate's still unknown, right? Just simple, good management makes a difference. Second thing that makes a difference is leadership. I mean, President Bush finally did an executive order on Freedom of Information Act because the Congress was about to pass a bill that would make him do something. And to shortcut that, even Senator Cornyn stood out in the White House driveway and said, well, that seems to be the motive for this executive order. But big surprise. By appointing a chief FOIA officer at each agency, you finally have somebody you can reach on the phone, hold accountable, who actually cares about it. You're seeing some changes. We can see it in some of the agencies, some real change from that executive order, and I give some credit. There are people inside who want to make it work, who salute and carry out the law. The third thing that makes a huge difference is congressional oversight. It's no accident, as they used to say in the Soviet Union. It's no coincidence, no accident that these reforms in the federal agencies started happening when Congress started paying attention and thinking about passing legislation of whole new rules agencies would have to deal with. And so all of a sudden you get greater responsiveness. But I still remember sitting in a congressional hearing room back in maybe 1989, I think Jim Baker, new Secretary of State, meeting his appropriators for the first time. Senator Leahy was one of his appropriators for foreign operations. And Senator Leahy, at the end of the hearing about all the things State Department's doing around the world, says, you know, Secretary Baker, I think the State Department has about a 12-year backlog on its freedom of information request. What's up with that already? And Secretary Baker, oh, I didn't know that. Went back to the State Department, found $1 million in the Secretary's administrative fund, hired a whole bunch of retired ambassadors to come in and do some reviews. And by George, they cleared up a big chunk of that backlog. Of course, today, the backlog is back. Oldest freedom of information request in the United States government, unfortunately, is at the State Department, and it's old enough to enlist in the 1st Air Cavalry Division and go to Iraq because it's 18 years old.
Judge Lambert?
I just had one other subject we didn't touch on, and it's a subject near and dear to district judges' hearts because the D.C. Circuit has ruled that even if the party doesn't raise segregability, I can be reversed because I didn't sua sponte make a specific finding of segregability. And that applies to B1 as well as any other exemption. So having been reversed my share of times by the D.C. Circuit, it's a little anomalous I would be here on this panel, but in any event, I have learned my lesson about segregability. And since I've got to make a sua sponte finding, that means I've got to get in the agency affidavit or in the record somewhere, some basis to find that there's no part of this classified document that can't be segregated out, and I've got to have enough information to make that finding. And even if the party doesn't raise it, the D.C. Circuit has told me I sua sponte have that duty.
Okay. Last question. I remember several years ago when I was still on the circuit, we had a judicial conference, and it was about Constitution, and Chief Justice Rehnquist and Senator Leahy were both there, and I asked them, you know, if you could make one change in the Constitution, what would it be? I'm ashamed to say I don't remember Chief Justice Rehnquist's reply, but I do remember Senator Leahy. He said, I would make FOIA a constitutional right, which is where he placed it. Now, what I'm asking you is there any single reform we already haven't talked about that you think would make a difference in this area of Exemption 1 and national security? Just one thing, if you could choose, whether it's an amendment, whether it's a different classification system, whether some people have even suggested a kind of a secret court like the FISA court where everybody had a security clearance, so therefore you could debate out the relative merits of risks, et cetera. I'll start with you, Stuart.
Yeah, I do not think FOIA is going to solve the problem that we think we have in the national security community, a problem that I think it's fair to say does exist, that people do want to bury their mistakes. It's a blunt instrument. People are throwing cases like this in the dark and hoping that maybe they'll turn something up, and there's so much material out there that is legitimately classified that finding the stuff where people have hidden a mistake improperly is almost a matter of luck. So I actually don't think FOIA is going to solve the problem, particularly with the backlogs we have now. And I actually think that disclosure through the archives is more likely to produce the kinds of insights into what was really going on in people's heads than these individual FOIA cases. So I would focus more on what can you get released through the archives. There are risks in that, but I think that at the end of the day, secrets that are 20 years old are a lot less likely to be something that has to be protected than secrets that are a year old. And that's more likely to tell us what was going on. But maybe that's because I'm old enough to remember the disputes, and so I still want to read the stories that come out of the archives.
I don't have any magic solution. I do think that what we've talked about today, and a lot of my colleagues are here, are something that judges need to take to heart, and that is we've got to do our job with the current statute. There are statutory changes that may help, but judges have got to do our job to make the statute work now, and I certainly am going to rededicate myself to doing that after this discussion.
Tom?
There's a culture of secrecy, and it's a universal law of every bureaucracy in the world. And the idea that we can, by good intentions and by statutory declarations, change that core human nature reality, core expanded in a bureaucratic sense to become an iron law of how you actually regulate government, is rolling a stone up the hill like Sisyphus. And yet at the same time, what we've said as a country is that King Louis was wrong when he said l'état c'est moi, or that the information belongs to the government. It doesn't belong to the government. Government is just custodians, temporary custodians of it. It actually belongs to the citizens. And you asked me, what one thing would you do to try to make it work? I carry around this little copy of a document written by people who are way more brilliant than I'll ever be, that posits a system of checks and balances to make government work. Sometimes that creates gridlock, but in our Constitution it says you got to have judges that do their job. You got to have congressional members of Congress and oversight committees that do their job. You got to have professionals in the executive branch who understand it's not only the law needed to carry out, but actually government works better the more open it is. Fundamental assumption of the Constitution. We're going to make better decisions as a government if we bring in more and not if we hide it in a hothouse and grow orchids like Jim Angleton did. And so there's not a magic bullet. I totally agree. But our government's going to work better. We're going to have a more democratic and accountable system. We're going to have power checked and balanced. And all those things are worthy goals, and I hope we'll all rededicate ourselves.
I think that was probably Chief Justice Rehnquist's answer that I forgot. Professor?
I don't know much Swedish, but the word ombudsman has been around since the 1770s. It's worked in other countries. The countries that have learned from us have not stuck with our Freedom of Information Act alone. They put in systems like ombuds. They put in checks and balances. They've got a more aggressive response by the courts than we do. Learn globally, practice locally about the access of the public, building greater trust. We have a system that seems to me to be broken at the moment. Judges can do their part, as Judge Lamberth has well articulated today, to fix that system, and or Congress could address it. But for the moment, do the best you can with what you have.
It's interesting because, you know, last time I looked, one of the foundations I worked with abroad, one of its priorities is Freedom of Information Act legislation and implementation. 52 countries in the last decade and a half have adopted Freedom of Information Act. And when cases which we encourage cases to be brought. What do? Believe it or not, they start citing law, including the D.C. Circuit law. So it has ramifications that go beyond this room.
One of the things you all talked about was how to improve this process. And I have always thought that should Congress folks who passed the statute but exempted themselves from the statute spent 6 months on a detail in a Freedom of Information Act office, and the judges who hear the cases, who also exempt from the FOIA, spent 6 months detailed to a Freedom of Information Act office, things would improve significantly because there would be a clear understanding about what the responsibilities, the obligations, the lack of resources, the challenges, how much your hands are tied. I, by the way, am a access professional, have been for almost 30 years. I enjoy working with the Freedom of Information Act, but resources is an issue.
Thank you.
You should let requesters do 6 months too. I'd really enjoy it. Come in, work in your office, that'd be great.
Okay.
In Ohio, one of the state senators responded to a request, even though the state senate was not subject to the disclosure requirements of the Ohio Freedom of Information law. His staff didn't know that. They called me up and said, you can come up to Columbus and get these boxes. I got the boxes. I found out that the tort reform law had been written here in Washington, D.C. by the tobacco industry's lawyer and then adopted in total by the Ohio State Senate. I would not have known that had they not made the mistake and disclosed the document.
I have to say, speaking on behalf of the executive branch, nothing would be better for us in the end than for Congress and the courts to be subject to exactly the same standards that we have.
All right, we've touched a nerve there. Please, Judge Santel.
I recall the occasion when Senator Leahy said he would make it a constitutional right.
Right.
I was seated next to Oliver Gash. Oliver said if he did make it a constitutional right, I would make him a judge and require that he hear all the cases that would be generated.
Okay. Thank you.